Greetings, class. I wanted to give you a little bit of an introduction to dispute resolution under international law. That's one of the sections in your chapter. It's chapter 8. So, what happens when you have a business and you're doing business with a business in another country and you have a dispute? Well, probably the most common way to resolve that dispute is using arbitration. Now, you may remember arbitration from earlier. That's when you have a third party who hears the case and resolves it for you. In the case of international transactions, then you're able to get an arbitrator who has experience in the international arena. There are several places that you can go, from locally, the Better Business Bureau, to internationally. The International Chamber of Commerce has a group of arbitrators who are experienced in international law, and they can hear and decide the dispute. Also, increasingly, there is the option of online arbitration. And so that would be that you'd submit this dispute to someone online, and that online person would be able to decide the dispute for you. Now, you may be looking at the picture that I have for this slide and wondering, what's that got to do with arbitration? The idea is that Iron Man, who's in the middle, would be the arbitrator, and you have on the left, I'm not sure who he is. I just thought it was a cool picture. It seems like he's someone like Green Lantern, someone like that, although he's not green. And on the right side, you have the Tin Man from The Wizard of Oz. So those are the two parties who have this dispute to be heard, and then Iron Man in the middle would be the one who would hear the dispute and then decide it. That can be either in person or it could be online, but that's the common way people resolve international disputes. Another way of resolving an international dispute is to go before the courts of international organizations. There are a number of international organizations. The book talks about the European Union, the EU, as one of those international organizations. The EU has a very detailed format for hearing and resolving disputes. And so that is one way to have a dispute resolved. I believe it's Google right now that's before the EU to resolve privacy issues related to Google searches. And I believe they're close to reaching an agreement. The idea, again, though, is that someone outside, in this case, it would be a court, that would hear and decide the dispute. In the case of the courts of international organizations, your country has to be a member of that organization in order for the dispute to be heard there. So since the US is not a member of the EU, we would not normally be able to have cases heard before the EU unless you're doing business with a business that's in a country that's a member of the European Union. But that's another way to resolve disputes. Still another way, which is probably the second most common, would be through the national courts of the particular countries. In the case of the United States, that would be the federal courts. So I have a picture here that actually isn't a courthouse, it's of an old post office, but you get the general idea that you would take the dispute into the federal court system in the US. So if you're a company in the US and you have a dispute with a company in some other country, then one recourse would be to file the case in the US federal courts. Of course, there has to be sufficient contacts and other issues that are beyond the scope of this brief introduction, but the national courts would be a way of resolving the disputes. So we've had several that are mentioned already. One is arbitration, one is the courts of international organizations. The third would be the national courts. And then the final way that I want to briefly introduce you to in terms of resolving international disputes, you can see from the picture, on the slide the United Nations. That's the International Court of Justice, or what's sometimes called the World Court. And the World Court is part of the United Nations. There are 9 justices. No more than 2 can come from any country. The International Court of Justice, its jurisdiction is limited, though. It primarily hears cases where there are disputes between nations, that is, between, they call them states, which is kind of a confusing term from the United States, but disputes between nations. So that if the US had a dispute with France, then one way that it could be heard would be to go to the International Court of Justice. As a practical matter for businesses, this is not a court that a business would be using because the business isn't a country. The thing with the International Court of Justice, in addition to how it's limited in the kinds of disputes it can hear, it also depends on voluntary compliance. So that means that the country who is being sued voluntarily agrees to the jurisdiction of the court and then also voluntarily complies. In other words, once the court makes a decision, the decision is not self-enforcing. Instead, the country that lost has to voluntarily agree to comply with the decision of the International Court of Justice. And so, as you can guess, depending on whether they agree with it or not, they may not follow that court decision. So those are the 4 methods of resolving international disputes that I wanted to highlight in this presentation.